Hello there, this is Professor Nathenson. This is the first in a number of videos I'm recording this spring, June 2016, at St. Thomas University School of Law as part of our review for our JD students who are taking the July 2016 bar. Good afternoon, everybody. I'm going to be recording these videos in a series, and what we'll do is we'll have different subjects recorded in different videos. And I'm going to stop the camera in between, and these are later going to be posted onto YouTube. Let me briefly explain the approach that I'm going to take. Up on the board, I have the 2016 MBE subject matter outline. I would assume you've already seen this before. The relevant law that's going to be covered on the July 2016 bar exam in relation to civil procedure is in this handout up here. And there's a couple of very important things that are worth noting. So I'm going to let you know some of the subjects that are more important and less important. And then I'm going to show you some of the resources that you can use in your studies of civil procedure in preparation for the 2016 bar exam. Well, let's start off here with the outline. First, what version of the FRCP are you responsible for? Okay. Now, I see a lot of familiar faces in this room, a lot of people who were in my Civ Pro class, or who I saw in some of my intellectual property classes, or who served as my ALI. Good to see you all here today. The version of the FRCP that you're responsible for is the version that went into effect in December of last year, December 2015. Okay. There's a couple of changes that are quite important that I'll get to in a moment. But if you're working off of the version of the FRCP that you used in my class 2 or 3 years ago, that version is no longer up to date. And I'll highlight a few of those changes in a moment. The second thing worth noting regarding the MBE is what topics are more likely to be tested than others. Okay, on the MBE, there's going to be 27 questions devoted to civil procedure. Okay? 2/3 of those questions come from a subset of topics on this outline, and the other third come from other topics. Now let's look up here. 2/3 of the questions are based on categories 1, 4, and 5. All right? 2/3 of 27, and that's 18 questions. Going to come from categories 1, 3, and 5. Jurisdiction and venue, that's personal and subject matter jurisdiction, venue, pretrial procedure, all right, and then motions, such as a summary judgment motion. I am going to spend the bulk of our time on selected topics from those areas of the outline. The remaining topics on the outline, namely categories 2, 4, 6, and 7 are also testable, such as number 2, law applied by federal courts, theory doctrine, right? Among other things. 4, the right to jury trial. 6, default judgments, jury verdicts, judicial findings. Number 7, appealability and review. All of those can be tested as well, but they're only going to be 9 of the 27 questions. So that tells you something important about where to put your study efforts. You know, obviously, it's not possible in a 3-hour review to go over every aspect of every topic from civil procedure. So instead, my approach is going to be to go over selected topics, and even within those topics, sometimes my coverage is going to be cursory or basic, or even just hitting up things that I think, in my own opinion, are likely to be tested or very testable on the MBE. So I'm going to be picking and choosing in a way that's geared towards helping you in your preparation for the bar exam. For anybody that's watching at home, keep that caveat in mind. I'm not covering everything. I'm not covering everything in detail. If you're a JD student watching this video, I hope you find it helpful, but this isn't nearly as detailed or as comprehensive as you would expect to be in a JD review, and the expectations for the MBE as compared to the JD exam are going to be very different, right? Today, unlike a JD exam, I'm not going to be talking about a lot of shades of gray. I'm going to be mostly talking about black letter law. Okay, now let's see what the next thing on the agenda is. You guys may know or you may not know, but I'll share some stuff with you, which is hopefully not shameless self-promotion, though it probably is. I have 2 resources for you, which you might find to be valuable in your studies in preparation for the bar. The first is my YouTube channel. And you can go to that by typing in youtube.com, then my full name, Ira Stephen Nathenson. All right? Ira, I-R-A-S-T-E-V-E-N, Nathenson, N-A-T-H-E-N-S-O-N. The YouTube channel is right there. You can find videos. Videos are sorted by various categories. Oh, there we go. Various categories. Personal jurisdiction, subject matter, review sessions, and what have you. You can also, if you're so inclined, subscribe to the channel, and when I post new videos, then that should hopefully show up in your feed as well. And indeed, the videos I'm recording today will be online in a matter of just days. The second resource that you might find to be helpful is my website itself at nathenson.org. And if you go to my site, you'll see that I have a lot of resources there. If you want, you can just tap right down there on Civ Pro MBE resources. And you will see that I have a whole lot of categories of study materials organized by topics. So, for example, if you tap on personal jurisdiction, you'll see links not just to videos, but also problem sets, flow charts, guides, diagrams, questions and answers, things like that. So hopefully you'll find those things to be helpful. The last thing I'm going to do in this initial introductory video is very quickly note some of the changes to the Federal Rules of Civil Procedure starting in 2015. And here I'm just going to tell you briefly, and then you can look them up or wait till the part of the video where I get to them in proper context. I can think of 3 major changes that ought to be brought to your attention at this moment. The first is the change to the timing for the service of the summons and complaint under Rule 4M. All right, when you were in my class, we learned that that time was 120 days from the filing of the complaint. Within those 120 days, which is approximately 4 months, the plaintiff must have the summons and complaint served on a defendant. That's 90 days now. And that change affects not just the time for service and summons and complaint, but it also changes relation back analysis under Rule 15C1C. Under 15C1C, the changing of a party, or the naming of a party, or by judicial fiat, the adding of a party, can relate back to the date of an earlier pleading as long as a number of conditions are met, and several of those conditions is the defendant to be added or changed must receive notice to avoid prejudice and knowledge of a plaintiff's mistake within the 4M period, which used to be 120 days, now it's 90. Big change, totally testable, will be a way for the Board of Bar Examiners to catch somebody who's not paying attention to the changing of the dates. A second change, which is perhaps somewhat less testable, I'll note it very briefly, involves the scope of discovery under Rule 26 of B1. What the rulemakers did is move some of the language from with proportionality requirements from other parts of Rule 26 and moved it into the scope of discovery under Rule 26B1. It also made a number of other changes to the scope of discovery under Rule 26B1. I'm probably not going to have time to get to discovery today, but I want to bring to your attention the changes to Rule 26B1. Make sure you read up on it. Make sure the information or study guides you use are using the current version. I'm assuming if you're using the current versions of Barbary or Themis or some other reputable company, that they will be addressing the 2015 changes. A third change, which I don't know that it would be testable, but I'll note it quite briefly, is the deletion of Rule 84 and the appendix of forms that were attached to the FRCP. You may recall this from your studies of Iqbal and Twombly, when we talked about the presence of forms 11 and 12 in the appendix of forms, of trying to give guidance of how much detail is sufficient to show plausibility for purposes of the Iqbal plausibility standard. The Supreme Court deleted Rule 84, which incorporates the forms into the rules, and deleted the appendix of forms. It remains to be seen what effect that has on the status of pleading. I doubt that's going to be tested. But those are three major changes that I'm bringing briefly to your attention. What I'm going to do next is stop this camera, and then we're going to start a new video. Thank you for your time.